Everybody. Welcome to Alaska's another online event as part of Alaska Startup Week. So this is a week-long event. We're now into day 4, and we've got more events coming later today into Friday, and a couple of events across the state on the weekend as well. So today's event and presentation is intellectual property, and we'll be touching on all different aspects of that, including patents. But before I pass it over to David Park to introduce our panelists today, I want to acknowledge the traditional lands upon which we reside here in Fairbanks. We're on the Trothieta campus, which is on the traditional lands of the Nenana people of the lower Tanana River. And for all of those on traditional lands across the United States, I want to recognize those lands and the past, current, and future stewardship of those lands. So on that note, I'd like to pass it over to David Park from the Office of Intellectual Property and Commercialization and the Alaska Center ICE Innovation Commercialization Entrepreneurship Hub here at UF to introduce today's panelists. So over to you, David.
Thanks, Peter. Welcome everyone to our intellectual property overview. My name is once again David Park. I'm a patent attorney based out of Fairbanks and a program manager here at OIPC and Center ICE. Center ICE functions as an innovation accelerator, providing such things as seed funding, customer discovery, mentoring, networking, and ideation events. And our office, OIPC, engages more in the tech transfer side of things, in taking disclosures, obtaining intellectual property, and forming license agreements. So we really function to transfer research results from our UAF and UAS campuses to the commercial marketplace for the public benefit. And as you could tell, intellectual property in all its various forms is a valuable part of research, not only at our university, but it can really be very valuable business assets, ranging from multinational corporations to the beginning stage startup. So I'm very, very happy to have Charlie Brown here with us today to give an overview on this topic. Charlie is a partner, Charlie is a partner at the law firm of Ballard Spahr, based out of Atlanta, Georgia, and he's a very longtime friend and outside counsel of the University of Alaska. He's a registered patent attorney with substantial experience in both patent prosecution, obtaining the patents, and litigation, and portfolio development. And he leads the electrical, software, and business methods team at Ballard. Thank you so much for being here, Charlie. Now I'll stop share here and you can start.
Excellent. Thank you. Let's see. We know if this is if you guys see the slide.
Yes, that looks good.
Excellent. Great. Well, thanks again. Happy to be here. I wish I was there in person. I've done this talk in person before, and I was hoping by this year it'd be in person again, but alas, it was not to be. But fingers crossed for next year. As it was mentioned, I've been assisting the university with their intellectual property for basically my entire career. So going back to about 2003, 2004 timeframe, but my firm has represented the university since before then. So we've been representing Alaska for quite a while. My wife is from Alaska. And her parents just finally moved down to the lower 48 a year or two ago. So today I'm going to talk about intellectual property and in the university context and then also in the startup context. When we talk about intellectual property, what are we talking about? We're generally talking about, for the most part, 4 things: patents, trade secrets, copyrights, and trademarks. And today, hopefully when you leave, you'll know which is which, what the differences are between them, and how they may apply to your business. Now, the purpose of IP, right? So the purpose for IP, generally speaking, is to stop someone else from doing something. Protect what is yours, and so that's often referred to as creating a barrier to competitor entry. Particularly with a patent, for example, a patent is a limited monopoly to make, use, and sell, or to stop people from using, and selling what you've invented. It can also, having a large IP portfolio or strong IP portfolio can be very useful when it comes time to negotiate contracts and for licensing. And then also it's a stamp of approval, right? We're still seeing today, commercials where, a product is patented, for example, and that sort of is the government seal of approval that this is an innovative product, and it's something that's new and innovative. And also, validation of concepts. And this comes in a lot of times with grant applications where you're filing a patent application on technology, and that goes in your grant application that can, oftentimes support the awarding of a grant. Now, let's just sort of where are the universities lately? And so this is a report that came out last year, and effectively, what you can see from these few graphs are that, on the left, where, or say in the middle, where you see patents issued each year to U.S. universities, has increased significantly over the years. This study that came out last year only looked at data up to about 2017, but as you can see, issued U.S. patents to universities has increased and continues to increase to this day. And similarly, the number of spin out or startup companies that are coming out of universities is just continuing to grow at an astronomical rate. And then, what this study also determined was that, income that universities have derived from licensed IP has gone from around 200 million or so in the 90s to, in the aggregate, about 3 billion by around 2015. And as you can tell, that's a huge increase, and it's attributable to the innovative efforts of the faculty and students that are in these universities. And so there's another organization that puts out an annual survey that asks certain universities, that are part of the organization, how to go, what have you been doing? And so in 2020, what we've found are that the universities had a big uptick in a lot of activity. More startups were formed in 2020 than in 2019. In fact, this is a record since I think this licensing survey was started, that over 1,100 startups were formed. And what was interesting was a lot of the innovation driving was through licensing to small entrepreneurial businesses. About 3/4 of the licenses and options that were exercised from universities were to startups and small businesses. And as you can see in this next slide, this gets a little bit into percent of licenses to smaller companies, whether they be startup or small entities. You see that effectively dwarfs out licenses that the University Tech Transfer offices were granting to large, the GEs of the world. Well, who knows? GE's about to split, as we all know. Who knows how that's going to shake out? And then more particularly to the startups formed, like I said, the startups increased over 2 years. There was a dip in the number of startups per year in 2019, but in 2020 we're still up over the 2018 numbers, which is solid. And about 69% of the startups that were formed were located in their home state, which sort of continues the preference for staying close to the originating institution. And on average, each responding university formed about 6 or so startups in 2020, and it works out to be about 1 startup per $83 million in research expenditures is where it sort of comes down. And so what's the university's role in innovation? Well, first off, the university's primary role is to teach, conduct research, and serve the community, and recruit, reward, retain faculty. And then at the end of the day, train a highly skilled technical workforce and create new tech. And all of this helps to promote economic development. And the startup plays a role in that the startup can provide the resources needed to commercialize the technology that comes out of universities, helps create jobs for the university graduates, and then also generate funding sources, financial resources for the university and the state, both through product sales and licensing and obtaining external investment through angel funders, VCs, and the like. Now, getting down to some brass tacks on the IP, we'll start off with patents. And patents were sort of born out of the Constitution. Article 1, Section 8, Clause 8 established that the Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That is, in other words, a patent. And what's important here is the language exclusive right, because the right is not an affirmative right. So as I mentioned a little earlier, how a patent is a limited monopoly to stop someone else from making, using, or selling what you've invented. It's not the right for you yourself to make, use, or sell what you've invented. And so it's a little bit tricky to think about, but it's really the right to stop someone else from doing it. And it's not an affirmative right for you to do it yourself. Also, when we talk about patents, we have to talk about what country you're in, because there is no worldwide patent, right? There's no international patent. Now, there is a mechanism by which you can file an application that will make it easier for you to file patent applications in other countries, but there is no ultimate patent that would give you patent rights around the world or in more than one country. And so, if you want to have a patent, you have to pick a country to get the patent in, or countries, and that patent is good and allows you to stop someone from making, using, or selling in that country, or exporting, or importing into the country where you have a patent, your invention. There are a few different types of patent applications. A type you'll hear about a lot is a provisional patent application. A provisional patent application typically serves a purpose of locking in a date. The provisional application is never reviewed by the patent office, and it will never become a patent itself. You can file a provisional application in any form or format. You can file a PowerPoint presentation if you wanted as a provisional application, but there are some drawbacks to that. But what the provisional application does is it locks in that date and says nothing after the date of that provisional application filing can count against you for prior art purposes. And prior art is basically all the pre-existing, just write-ups, earlier patents, journal articles, products that are in the market that will be used against your patent application to try to show that you did not invent something that's new or not obvious. And so it basically locks in a date, and after that date, no more prior art can be used against you, but only for what you've disclosed in that provisional, which is why I say you could file a PowerPoint, but that may not be the wisest choice, because there's a good chance that a PowerPoint presentation isn't going to be the most complete description of what you've invented. And when you file that provisional, you have 1 year within which to file your utility, or also called the non-provisional patent application, and any foreign applications that you wish to file. And the purpose of the provisional, again, is to describe your invention and lock in that date for prior art purposes. Now, after that year has passed, you follow up with your non-provisional patent application, which has very formal requirements for what goes into it. For example, you have to have what's called the specification, which is a detailed write-up that explains how to make and use the invention, and includes a set of claims, which are detailed statements of your invention that really set out the metes and bounds of what you've invented. The claims are what the patent office will review when determining if you've invented something or not. And what that means is for the prior art will be looked at to find what you've put in your claim. A patent application, a non-provisional patent application will, like I said, claim priority to that provisional. And so when they look for the prior art, if you've done a good job of filing a very robust provisional, the patent office cannot look for prior art after the date of the provisional filing. And as far as term, once your patent application is granted to the patent office, you'll get an issued patent that will last 20 years from the filing date of the non-provisional, not the provisional. And then the patent office will apply certain standards to the application, which I'll get into a little bit more in a few minutes, to talk about whether or not you've got something that is truly new and not obvious. So a lot of people ask, why would you bother with the provisional? Why wouldn't you just file straight to non-provisional? Well, you can. It just really depends on your circumstances. Sometimes you may want to lock in that date. You're not sure if you really want to move forward with full patent protection on something, and you just want to go ahead and get your stake in the ground as far as a date's concerned. Or maybe you want to patent your invention, but you want a little bit more time to further refine it. But you know enough about it right now that you can sufficiently describe and demonstrate that you're in possession of an invention. And so you can go ahead and get that on paper without those formal requirements that are in the non-provisional. You can immediately list your product or service as patent pending once you file the provisional. And like I said, since it's informal, you can do them relatively quickly. And we're also, and I'll mention this in a later slide, under the American Invents Act, one of the changes to the patent law in the United States was it shifted us from a sort of first to invent system to a first inventor to file system, which you can think of it in one way as a race to the patent office. Whereas before we used to have a procedure by which we could really determine who truly invented something first, regardless of when they filed their patent application. But now the patent office is more focused on when you filed your patent application. So there's a little bit more pressure on companies to file their patent applications quickly in order to beat someone else to the patent office. So one way to think about it is this is how a timeline might look for an example of patent filing strategy. You might file your provisional and then a year later file your non-provisional. And you could also a year later file what's known as the Patent Cooperation Treaty application, which is what I mentioned a little earlier, which sometimes people call an international patent application, but a PCT application is never going to become a patent itself. It'll never become an international patent or a PCT patent. It's just an application that you can file, and when a certain time period is passed, you can use that PCT application as a mechanism to enter the patent systems of all the member countries of the PCT. And so in this example here, the timing for when you enter those sort of foreign patent offices is 30 or 31 months from your earliest priority date. And so in this example here, if you filed the provisional, the 30 months would be measured from the provisional date. And so 18 months after you filed the PCT in this example is when you'd be looking to file a foreign application. Also, your patent application will publish 18 months from its earliest priority date, because remember the monopoly you're getting from the government, the sort of like the barter, the exchange you're making with the government is in exchange for that limited monopoly, you are agreeing to teach the world how to make and use your invention. And so your application will publish, and that publication will include all those claims and drawings and specification of how to make and use your invention. Now, there's a mechanism by which you can not have your application published. And essentially what you have to do is agree not to file your application in any foreign countries. If you do that, you can keep your application secret until it issues as a patent, if ever. And once you've filed your non-provisional patent application, it goes through the patent process. And in this example, we're starting from the very beginning. If you're a professor or researcher or an inventor at a startup, you will write up your invention in some form of invention disclosure form, right? Which some sort of document to memorialize what you've invented. And a patentability search can be conducted. And what that is a review of the prior art to see, has someone else already done what you've claimed to have invented? Is it gonna be a hard time or maybe an easier time trying to get your invention through the patent office? And then, based on the results of the patentability search, you'll prepare and file your application. Then you wait. So a few years will pass, although the other day, I got an office action from the patent office 2 weeks after we filed an application. It was kind of mind blowing. That's the earliest I've ever seen it by a wide margin. But normally it's a couple years. And then after a few years pass, a patent examiner will get around to your application, will read it, and will conduct a search of the prior art using the earliest priority date. If you filed a provisional, it'll go all the way back to that date. And the examiner will issue an office action 9 times out of 10 rejecting your application, saying, no, you can't have a patent because someone's done it before. And then that begins the back and forth with the patent office, where we prepare a response where we say, well, patent office, we hear what you're saying, but we've changed we've tweaked our claims a little bit. And now we think that we're clear of the prior art, or maybe we think the patent office interpreted the prior art incorrectly, in which case we'll present a different view of the prior art. And this will go on for a few times until either we agree that there's nothing there that's patentable, or the patent office identifies that yes, this is a patentable invention. The examiner will issue what's called a notice of allowance, and then you'll pay an issue fee and you'll get an issue patent. Now let's talk about what that examiner is doing. That examiner, when they're assessing your patent, is they're trying to figure out if you've got something that is patentable. And what is patentable? Well, there's some court decisions that have basically said anything under the sun that can be made by the hand of man is patentable. I don't know if that's necessarily true anymore after some recent Supreme Court case law, but effectively, patentable inventions fall into these categories that are laid out in the statute, and it's any process, machine, manufacturer, or composition of matter. And most inventions will fall under those categories. And examples of those are, machines are pretty easy to think about, something with parts that move or interact. A composition would be a drug, chemical, of that nature, article of manufacture, a static item, maybe a new tool. And then a method of process could be, a method of making something, or software method. And that's where it's my background. And software methods fall under the method of process category of the kinds of things that we file patent applications on. What are we not allowed to get patents on? We're not allowed to get patents on laws of nature, natural phenomena, or abstract ideas. And the Supreme Court in 2014 issued a decision that reinforced this concept that we can't get patents on abstract ideas, but they modified a little bit the way we were thinking of what an abstract idea is, and that's still evolving today. And frankly, that could be the topic for a whole other discussion of where we are in the state of the law on what's an abstract idea. But right now, what we think of it is we're not allowed to get patents on mental processes or things that are analogous to a mental process, or mathematical formulas, or methods of organizing human behavior. Things in that category, those categories are the types of things that fall under the abstract idea category. And so the patent office will examine your invention, your claim, and try to determine if you're trying to patent a law of nature, right? Are you trying to patent gravity, or are you trying to patent what is otherwise a mental process? And if so, they'll reject it by saying you're trying to claim non-patentable subject matter. They will also look at your patent claim and try to determine if your invention, your claim is novel. And by novel, I literally mean new, as in like the exact same thing does not already exist. And typically what that means is the patent office is looking for a single document, either an earlier patent application or earlier patent, or a IEEE article or something that describes every feature of your invention in the way in which you've arranged it in the claim. And if the patent office finds that, then they'll say your invention is not novel. The patent office will also look to see if your claim is obvious or not. And obviousness, there's a little bit more leeway there in arguing that, because the patent office may say, hey, we think what you've got is novel, is in the sense of we haven't found that someone has described the exact same thing in the exact same way. However, we've found 2 or more different documents that would combine together, have all of the elements of your claim, and it would be obvious to one of skill in the art to combine these references to arrive at your invention, and that there would be sort of a reasonable expectation of success in the combination of those references to arrive at your invention. Now, as in the novelty rejection, when we respond to these, we'll argue with the patent office. We may change the claim a little bit, but in this instance, sometimes we argue that while the references may teach the elements of our claim, that one of skill in the art would not have been motivated to combine these references, because perhaps maybe one of the references, discourages their combination, or perhaps the references were in different fields that no reasonable person would look to these two disparate fields to combine their teachings to come up with what we've claimed as our invention. There are other requirements as well that fall under a statute called 35 U.S.C. 112. They relate to enablement and written description in best mode. Enablement means, have you described your invention in a way that someone believes that you have really taught someone how to make and use it. And then written description really generally kind of gets at the concept of, have you written your application in a way that someone of skill in the art believes you were actually in possession of the invention and weren't really just kind of making it up. And then best mode requirement is not really required anymore, but it used to be more of a requirement. And an example of best mode would be if you maybe had a chemical invention where maybe you were making maybe you're making aspirin, and part of the process of making aspirin, you realized that at a certain temperature, you got a significantly higher yield of aspirin, then you would be required to disclose that ideal temperature that got the really good performance out of the process. So that's what the patent office will look at to assess whether or not you've got an invention or not. Now let's talk about who's an inventor. So this comes up a lot in university context, because there'll be oftentimes a lot of people contributing to a project that's sort of around an invention, and the question is who that's orbiting that project is an inventor and who's not. And so the courts have come up with this sort of definition of invention, and invention occurs in these sort of three stages or phases. There's conception of the invention, there's the reduction, activities leading towards reduction to practice, and then reduction to practice. Now, we are in a world where you don't actually have to literally reduce your invention to practice. We have a concept what's called constructive reduction to practice, which occurs when you write up and file your patent application in such a manner that someone of skill in the art would be able to go and practice the invention. That is effectively, constructively reducing your invention to practice, which means you don't actually have to build the invention. You don't actually have to write the software code or build the machine in order to get a patent application. Now, the patent office still has the right to sort of ask you to bring the invention in, and they're probably more likely to do that in the sense of a perpetual motion machine to sort of ask you to bring that thing in. But otherwise, a reduction in practice is now more on the constructive side. So the part of this phase that controls who and who is not an inventor is the conception phase. And there's a lot of case law on this, where all these fun poetic sentences where conception is the touchstone of inventorship. It's the formulation in the mind of the inventor of a definite and permanent idea of the complete and operative invention. And if you don't participate in conception, then you're not an inventor. And so, okay, but how do you figure that out, right? How do you figure out who conceived of an invention? Well, the way we do that is we look at those patent claims. The claims that we draft, remember the claims are that definition of your invention, your statement of invention. Those claims are the part of the application the patent office is going to look at and compare the prior art to see if you have something new and not obvious. We look at those claims, and if you are someone who contributed to the conception of at least one limitation of at least one claim, then you'd be an inventor on that patent application. But if you didn't contribute to the conception of one of those limitations of one of those claims, then you're not an inventor. And what happens a lot in the university context is there'll oftentimes be a manuscript or a journal article that's going to be associated with the invention, and there'll be a lot of authors on that paper, and it may include some graduate students who are maybe just running some experiments, or it may include some collaborators at a different university who maybe gave you some data. But the trick here is to remember authorship on a paper does not mean inventorship on a patent application. And as you can imagine, in the example I just gave, if someone just gave you some data that was useful for you to use in coming up with your invention, then they really didn't contribute to the conception of the invention. They were just helping you sort of create it and helping you reduce it to practice. And I use this paper as an example. This is the Higgs boson paper, and it's that ad et al. And that et al. Is over 5,000 people who contributed to the Higgs boson experiment several years ago. And so, not in a million years would anyone file a patent application with over 5,000 inventors. So that's something we oftentimes have to do, is sort of suss out who is and isn't an inventor, and figure out who conceived of the invention and who was someone who sometimes we refer to as skilled hands that helped reduce it to practice. Next, we'll talk about the 1 year rule you have to keep in mind. So when you've come up with an invention and maybe you haven't filed your patent application yet, if you disclose your invention publicly, you have 1 year from that date to file your patent application at the Patent Office. If you go too long, if you go beyond a year, then you're not able to file a patent application on your invention, and you will have been deemed to have basically given your invention over to the public commons. And so that's why we often sort of tell people the best practice is to file your patent application before you disclose your invention to anyone outside your company or anyone other than yourself or your co-inventors. But the one question we get a lot, though, is what does it mean to be a public disclosure, right? Because I can sit here and say I've invented, like warp drive from Star Trek, but if I really did, that wouldn't really be a public disclosure of an invention, because I didn't teach you how to do it. I didn't give you enough information to enable you to go out and experiment a little bit and figure out how to do it yourself. And so a public disclosure, for it to count against you, it has to be enabling. And things that sometimes may trip up universities are that when you apply for a grant, grants are normally kept in confidence, especially if you label them confidential. But the date that those grants are funded, then that's the date that grant becomes available under a Freedom of Information Act or a FOIA request, which means that grant is now a public disclosure as of the date it gets funded. And so that's sort of a submarine lurking date that we need to always keep in mind if we filed for a grant, that we need to make sure and we haven't filed an application yet, that we file our patent application before the grant date. Another trap that we sometimes find in the university context is, when a paper or manuscript is submitted to a journal, there's often a pre-publication on the internet or some earlier sort of send out. We always got to stay ahead of that. And one thing to keep in mind is a public disclosure doesn't necessarily have to be, a lot of people think of it as like like you're talking to an audience. It doesn't have to be that way. It just has to be a document that is otherwise available to the public. The public doesn't ever have to have actually accessed it. And sort of the quintessential example is, a graduate thesis that only one copy exists in the world, and it's indexed and then a library at the university. Well, if that library, the university is open to public, then that thesis is a public disclosure, even though that's the only copy in the whole world and nobody ever checked it out. Other things we bump into in university context, or at conferences, posters and abstracts. Oftentimes those are circulated around before the conference, and then also you need to be careful of correspondence to anyone outside of your company or outside of the university. And then also, internal meetings. If anyone from the outside is part of your internal meeting, then you shouldn't discuss your invention, and you shouldn't discuss it for sure in any way that is enabling. So a lot of people ask, well, what can you talk about? Well, the first thing I respond with is, do you have to say anything at all? But if you do, then you need to file your patent application, and you can talk. And then once you do that, you can sort of talk about it however you'd like. Mind you, you have to only talk about what's in the four corners of that document. So if you file a patent application and then 2 months later come up with a great new feature of your invention, and that's not in the application, and you talk about that cool new feature, well, that patent application isn't going to sort of prevent that discussion of that public disclosure from counting against you with regards to that feature. Now, if you file a subsequent non-provisional application timely, then that disclosure of that new feature would fall within a year and wouldn't be a problem. But nonetheless, something to keep in mind. what you can say is whatever's in the document. So, 10 years ago now, there was this large change in the law. I previewed a little bit of it earlier, which changed us from a first to invent to a first inventor to file. And some of those changes beyond that are introduction of, for example, a new proceeding at the patent office where, for many years in Europe, you were able, once a patent issued in Europe, someone could go and challenge the patent in an administrative proceeding at the European Patent Office and sometimes get that patent overturned. And it was much cheaper and faster and easier to do that in an administrative level than in a court, which was really the only way to invalidate a patent here in the United States. Well, as part of the AIA, we implemented our own what we call post-grant proceedings, which allow for the sort of the administrative canceling of a patent, which typically those proceedings go hand in hand with district court litigation, but not always. And then the 1 year grace period we just talked about. The 1 year grace period used to be any disclosure by anyone of your invention. However, now the grace period applies only to disclosures made or derived from the inventor themselves. So if someone else disclosed your invention and that disclosure wasn't derived from you, then that disclosure could stop your patent application in its tracks. There's also a design patent. Now, up till now, we've been talking about utility patents, which protect the function or how an invention will work. A design patent, though, protects sort of an ornamental design, the ornamental features of something, and not the functional features of the thing you've invented or designed. Design patents are shorter than utility patents. They're only 14 years from the date they issue versus 20 years from the date of filing. And there is oftentimes a little bit of overlap between design patents and copyright, which we'll get into copyright in a minute, because copyright, as I'll discuss later, just covers the expression of an idea. And so you could have a drawing that is protected by copyright, but you could also have sort of the product that's created from that drawing, or even the product itself, covered as under a design patent. And so it provides you the exclusive right to your design. And this is an example of a design patent. And design patents don't have claims in the normal sense of using words, but design patents have claims that are more drawings. And so anything that's in a drawing in a design patent where you have a dashed line is something that the inventor excludes from their design. And the solid line would be something that the inventor is including in their design. So in this instance, the inventor is including, the sled, except for the person, right? They're not including the person in the design. They're not including the dogs in the design, but they're including the sort of the looks like a tubular frame sled that they're including as their design. Now, why would you go for a design patent? Well, people should probably remember that the sort of the Apple Samsung battles, patent battles of a few years ago, went on for a while, and there was a lot of money at stake, and design patents were part of that, where Apple had design patents on iPhone design and even icon design, right? Where the icons in an iPhone had little rounded corners rather than square corners, and those were part of a design patent. And overall, there was $500 million in damages. And so design patents can definitely add some diversity and weight to your portfolio.
Charlie, I have a question from the attendees before you jump onto the trade secrets and the next one. You mentioned software method as an example on the patent side, and that was a question brought up by one of the attendees. Could you briefly go into that before we go on to the next aspect of IP?
Yeah, so software is protectable by patent. Software is also protectable by copyright. And software is an area that was hit pretty hard by that decision in 2014, what we call the Alice decision, because at the time you could imagine software patents as a spectrum with what I'll call sort of hardcore software patents on one end, which would be inventions related to optimizing memory storage or RAM usage or multi-threading processes and those sorts of things. Those are sort of more hardcore software inventions. where they're truly directed at improving, how computers work and how they operate. And then on the other end, we used to have business methods, which were just ways of doing something. And they didn't really have to include a computer at all. In fact, there were people who got some joke patents, and one of them was a patent on a method of swinging on a swing, where you swing sort of like side to side on the swing, so front to back, to sort of prove a point. And in the middle there were what we would call computer implemented business methods, where it's a method that relies on a computer, but it's questionable how integral that method really is into the sort of the computational process. And that used to be our spectrum of, quote, software patents. And the Supreme Court in 2014, when they came down and said no patents on abstract ideas, which we already knew, but they sort of expanded a little bit our view of what is an abstract idea, and they definitely sort of lopped off the business method side of that spectrum. And so now the spectrum has two ends. One of it is those hardcore software inventions, and the other one is, computer implemented business methods. And that's where a lot of the battleground sort of is today on, if you have a method and it's implemented in a computer, is it patentable subject matter? Not is it new, and not is it non-obvious, that's a separate question, but is it patent, is it the kind of thing that we want to give patents on? And that's where we have to go through that analysis of, well, is this patent claiming what is otherwise a mental process? Despite the fact that you may include a computer in the claim, is the computer just there sort of as an ancillary thing, and it's really just using a computer for what computers are meant to be used for? Or have you, or are you claiming, a mathematical formula, or, and one way we try to get around that is by saying, well, this invention is improving, technology, and the technology that's being improved doesn't necessarily have to be computer technology. You could, you can make an argument, and these are successful at the patent office, where maybe an example is an invention that has software that helps a surgeon plan surgery. And so that software didn't necessarily qualify what I would say as sort of the hardcore kind of software patents, right? That software wasn't related to, improving, how memory or how data might be shuffled around in hardware, but it used a computer to help, plan and guide, how a surgery should go, sort of to maximize, patient outcome. And that was an improvement in that surgical technology. And that argument was successful at the patent office, and that software then got, that was an example of a software patent that is allowed. And so the patent office will also look to see is if you're claiming a mental process, are you otherwise claiming it in a way that it's being practically applied, or that there is some other sort of just, truly inventive concept that's just sort of really unconventional. And if so, then that can sometimes win the day. But a lot of people will say software is not patentable, and that's not true. Software is patentable every day, all day. It just depends on exactly what it is, what it's doing, and how it's doing it. Will really kind of control whether or not you're going to be able to successfully patent it.
That's great. Thanks. That is, it's on a sort of case by case, software by software, approach by approach basis. And so therefore the question to Jay, and he says, thanks for that, is just evaluating and working out and talking to somebody like yourselves, but on their company side, to get the advice on which is the approach to go down the IP to protect it for that business, whether it is a copyright or it is a patent, comes down to talking to somebody with the expertise in that area to help support the business to make the right application at the right time.
For sure. And I'll get into copyright in a minute, and because that's definitely a way to help protect software, but there are some extreme advantages to copywriting and patenting your software, but we'll get to that in just a few moments.
Perfect. I'll pass it back to you.
Great. So let's dip into trade secrets. And this is gonna sound like I'm being a little bit pedantic, but what is a trade secret? It's really kind of anything that you think is a secret, and that if it got out would be damaging to your business, right? And the formal definition is more like this, right? Formula, patterns, compilations, things, know-how that you have in your company that is not public and generally known, and you can keep it a secret, and you are sort of maintaining reasonable efforts to keep it a secret. And so what that means is it's not easily reversible, and it's something that you don't want to put in your materials that you sell to your customers, right? Like your trade secret is not something you just put out there, right? The classic example is the Coca-Cola formula, right? Where if Coke had patented the formula, then the patent would have expired, like 100 years ago now. Whereas if they kept keeping it as a trade secret, which can be indefinite, because it's a secret as long as you keep it that way. And so there's no registration costs. It's not limited in time. It's effective right now, and you don't have to tell anybody about it. But one time we oftentimes run into issues with clients. I don't know if anybody here is a fan of The Office, but there was an episode where Michael Scott declared bankruptcy, and he walks out of the office and he goes, "I declare bankruptcy," and that was the way he thought he was declaring bankruptcy. That was done, right? No, a lot of clients will say, "Oh, we'll just treat that as a trade secret." It's like, well, that's not enough. Just saying it's a trade secret does not make it a trade secret. You actually have to treat it like sort of like the lifeblood of your company depends on. Internal policies that stress its importance, training your employees on keeping things secret, not having the trade secret information on a server that's got a password on a sticky note that's on the monitor, these sorts of things. These are all examples of things that companies need to look into to sort of minimize the chance that trade secret will get out or otherwise be found out. And trade secrets typically come into play when a competitor leaves, or I'm sorry, an employee leaves and immediately becomes a competitor, and it sort of goes from 0 to fully operational in 2 or 3 weeks. You can generally kind of assume that there's been a theft of trade secret in there to bring an action in that regard. Now, if just because you consider something a trade secret doesn't mean that your competitors have to respect it and not try to figure it out by reverse engineering your product. And so if someone's able to take your product and figure out your trade secret sort of by reverse engineering or sort of analyzing it, then you have no cause of action. Also, trade secrets, unlike patents, don't protect against independent creation. So if someone else came up with the exact same Coke formula and did not in any way, shape, or form get any information or get the formula from Coca-Cola itself, Coke has no action against that person for independently coming up with their own formula. And so if someone else gets a hold of your trade secret through these sort of types of means, you have no recourse. So that's the sort of the caveat to trade secrets. They could be fantastically powerful, but you have to make sure it's the right kind of thing to protect the trade secret and that you actually treat it like a true trade secret. Now we'll jump into copyright. So what is a copyright? Copyrights protect works of authorship, fixed intangible media of expression. And the classic things we think of are literary works, songs, paintings, pictures, sculptures, movies, those sorts of things. And it's oftentimes referred to as a bundle of rights. There are copyrights in a work, and these are some of the rights to reproduce or perform, distribute, display, make derivative works. And if you have copyrighted material, you can license out some or all of these, right? You could, for example, if you have a copyrighted song, then you could license a radio station to play the song, but not to sell or make copies of it, and not to play it publicly in a concert. So you can restrict and control how your copyrighted information is used by licensing out these exclusive rights selectively. How do you get a copyright? Well, to some extent, all you have to do is create something. There's a common law copyright attaches when you have sort of fixed your work in the tangible medium. What does that mean? When you've painted the painting, when you've taken the picture, when you've written the software code, you have a copyright now. And you don't have to, and technically you don't ever have to register or do anything with that copyright. However, if you ever want to do something with that, then you definitely need to. If you want to sue someone for copyright infringement, that is a federal action, and you need to register your copyright with the Library of Congress. Because until you register your copyright, you can't sue anyone for copyright infringement. And if you register within 3 months of publishing your copyrighted work, there are certain benefits conveyed. For example, the ability to claim statutory damages. People might remember back when sort of the Napster heyday, where the RAAA was suing people for downloading like 5 songs and getting judgments of like $500,000 or something insane, even though it's like $1 a song. That was because they were able to rely on statutory damages and not have to prove, actual financial loss or otherwise financial gain to try to get a damages claim. And copyrights have a limited life. Right now, currently, it's life of the author plus 70 years, or if you paid someone to make a copyrighted work, then it's 95 years from the first publication, or 120 from creation, whichever shorter. Now, we'll see how this shakes out as Mickey Mouse continues to age, how long we'll get copyrights for. And so the takeaway here is copyright is the expression of the idea, not the idea itself. And it's an example from the software world, right? So the expression of the idea is this code on the left, right? This software code, written as it is an expression of an idea. The idea is a bubble sort, right? Sorting some numbers by just comparing 2 numbers, and if one's greater than, or smaller than the other, swapping their positions, right? And you do that enough times, you eventually go from an unordered series of numbers to an ordered series of numbers. And so if you have a copyright on this code, then you have the ability to prevent or to sue someone for copyright infringement if they had access to this code and copied this code. But you'd have no action against someone who wrote some different code that also did a bubble sort, because you don't have a copyright on the bubble sort idea. You just have a copyright on this particular expression. And this is this example, though, you may not even get a copyright in something as basic as this little expression I had here, because there's a concept called the merger doctrine where we don't allow people to get copyright protection on certain things, where there's only so many ways to express something that to, in effect, give someone a copyright on that would be to practically give them a patent on that idea. So that can prevent some instances of copyright protection attaching. Now, sort of try to hammer this home a little bit. There's this, just like trade secrets, a copyright does not protect you against independent creation. So if someone else wrote the exact same novel, or someone else took the exact same picture, or someone else painted the exact same painting, but they never had access to your painting or never heard of you and never copied, in fact, your painting, then there's no copyright infringement. And so that's where the power of the copyright fails a little bit, in that it doesn't protect against independent creation. So oftentimes copyright is brought to bear against wholesale copying, and at least in the software space, back in the day when companies were actually selling software on DVDs and CDs, people were making knockoff or cracked CDs of things. It was easy to make a copyright infringement claim, with the caveat being that none of the algorithms that were underlying those expressions were being protected, but it was the expressions themselves. And that's when we come into patents versus copyrights, right? Especially when it comes to that software question, right? So if you had a patent on your software, you can stop someone from making, using, or selling software that infringes your patent, regardless of whether they had access to your software code or even knew or heard about you, because patents do protect against independent creation. Whereas if you just had a copyright on your software code, the only thing you could do is if somebody had access and copied your code, then you could go after them for copyright infringement. Otherwise, you don't really have a copyright action. And so, there's obviously a lot more effort and expense in getting a patent, but that extra ability to go after independent creators, can sometimes be a game changer in the IP space.
Ollie, I've got one brief question, but as we're looking at the top of the hour before you jump into trademarks, let's say you've got a software system and you've got a copyright, but then you're updating your code as you're building on it and growing your software suite or your aspects of it, sub-programs, whatever. How does that connect on the copyrightability versus like one final version of a code that's done and is then used by your organization? How does that impact copyright versus patents if you're doing like updates and patches on the code?
Sure. And so that oftentimes gets very sort of situation dependent on like what is the feature, because sometimes you may come up with a feature that warrants a new patent filing. That, you know, this new feature that you've come up with is so innovative and novel over the existing product that you want to protect that. And the example I oftentimes give in this context is the undo feature of Word. And the reason I give this as an example is because at one point, like, I don't know, like over a decade or so ago, like our IT department installed some little widget in Word that I didn't really like. And when they uninstalled it, they also somehow broke my undo feature. So I couldn't undo anything, which could sometimes be problematic when you're writing a patent application and accidentally delete something or change something you shouldn't. And so I realized sort of the power of the undo feature. And I realized no one's going to buy a word processing program that does not have an undo feature. You just wouldn't buy it, right? And so if you had a patent on the concept of the idea of a word processing program, and then, you know, a year or two later, you come up with undo, then that may warrant a new patent filing, really, that said, hey, this is so novel and inventive and game changing that it warrants its own patent protection. So you may have a patent on the word processing program and then the undo feature of a word processing program. And so that may make you think about filing multiple patent applications as you develop your product. And then when it comes to the actual code that embodies those ideas, that sometimes gets a little bit into sort of like whatever kind of versioning system your company is using. You know, depending on, some companies may just say whenever we go from a version 1 to a version 2, then we'll do a new copyright registration, as opposed to 1 to 1.5 or something. But again, it's really easy to get a copyright registration, and so oftentimes, you know, it just makes sense to just once it's a big enough shift or a big enough sort of update, to just go ahead and register it again. But remember, you still have a copyright no matter what, because you've written it and you've expressed it. But that extra step of registration is always just a good thing to do as a formality. And so a lot of companies will just sort of set just milestones of like, whenever we go from a large shift from versioning, then we'll register it again, as opposed to updating it every time we change the code.
And I do know a few people will drop off, but it'd be great to hear on the trademarks. And if anybody's able to then watch afterwards, we'll make sure that the whole thing's recorded and put online. But we can keep going, and because I'd love to hear about trademarks, and I'm sure those that are watching afterwards will do. So I'll pass it back to you, Charlie.
Yeah, great. Apologies for going a little over. I'll go quickly. The final sort of feather in the cap is trademarks, right? What's a trademark? It's something that identifies the source of goods or services, right? So it's a symbol, a word, a sound that identifies where something came from. So that way, when you see this trademark, you know where it came from, and then you associate things with that. Maybe they're good things, maybe they're bad things. Maybe you think, wow, that's going to be a good product, or maybe you think that's going to be terrible and I'm going to stay clear of it. But it is a source identifier, and it is used in commerce, which is a big difference between all the other forms of intellectual property, because you can get a copyright, you can get a patent, you can have a trade secret, and never actually use any of those underlying products in commerce. You may never build the thing you patented. You may never sell the code you copyrighted. But if you want to get a trademark, you have to use that trademark in commerce. You have to sell something under that trademark. And the purpose is to prevent people from we want to stop someone from using something similar to sell something similar, to sort of ride off of your coattails, ride off of your goodwill. And a trademark can last forever. So as long as you are paying the government their sort of their renewal fees, and you're using the mark in commerce, you can keep a trademark going indefinitely. And I give these examples. Adidas has their trademark down to literally a science. They have a formula that you can look at and apply to stripes to see if they fall within what Adidas considers its trademarked 3-stripe symbol. And so there's a lot of money and goodwill wrapped up in trademarks. And the key thing about trademarks is you can lose them, right? So like if you stop using them in commerce, you can lose them. If you let other people infringe on your trademark, if you let other people use your mark in commerce and you don't stop them, then that inaction can cause you to lose your trademark rights. And if you use your trademark improperly, right? A lot of companies will get a trademark, but then they won't use the trademark in the way that they got it registered, and that improper use can sometimes, void effectively the trademark. Similarly, there's what we call genericide, which is when you have a trademark that everyone just starts using as a generic term for the product in the market, and you've now lost sort of like the source identifier, right? So aspirin, cellophane, these used to be trademarks, and now everyone just calls aspirin, well aspirin, right? No one says Bayer aspirin. It's all aspirin. And then the failure to police, that's just sort of like that, going back to if someone is infringing on your trademark or has a trademark that's confusingly similar to yours, and you just let them continue to sell and don't try to stop them, then that failure to police can cause you to lose your trademark. There's an example of a lot of people know the company Monster Cables, right? You go to Best Buy and there's like an AV cable that's really sometimes a little more on the more expensive side. They're very aggressive at enforcing their trademarks. And for the example, they've sued a company, I think it was in Florida, that had a putt-putt golf, like Monster putt-putt golf or something like that. They sued them for getting too close to their trademark. But nonetheless, that's where trademarks come in. That wraps it up for me. Like I said, apologize for going a little over.
It's very, very informative. We've got one last question from the audience. We've got William calling in online,
Sure.
and he says, sort of prior art, does that only apply to patents and not copyrights? Because you highlighted that copyrights can be for anything and patents have that prior art search. Is that the case?
Yes, so prior art only applies to patents. For copyrights, the standard that's applied is it has to be sufficiently sort of like original and some minimal amount of creativity. So there is some law about what that sometimes means. For example, an alphabetical, like phone books, maybe not copyrightable because it's just an ordinary arrangement of information, not too much creativity in that. But other arrangements of data may be sufficiently creative and original to satisfy the creativity hurdle. But yeah, they don't look to see if someone else has painted a similar painting to decide whether or not to give you a copyright.
Great. Thanks for that, Charlie. I'll pass it over to David to wrap us up for today.
Great.
Okay, thanks, Charlie. I just really appreciate your coming and giving us this webinar, and I think it was just very informative. I know we're a little bit over, but I just wanted to ask you if you had any advice with respect to intellectual property for startups, maybe just one quick piece of advice.
Manage your public disclosures. Spend some money on a provisional. I've worked with startup companies where they have a product I think it's going to change the world. It's going to be huge, and it's like, well, if it is, then there's a little bit of sort of put your money where your mouth is. Protect what you've innovated, to protect it, because otherwise it's nothing for larger companies to see what you're doing and just sort of rip it and go. And sometimes the biggest stick you can have in that negotiation is a patent application. I know it sounds self-serving, like, oh, do 5 more patents, but honestly, that's it. And then understand that getting a patent is not the end. There's getting a patent, and then there's coming up with a product, and the patent is sort of the baseball bat in your closet, right? It's sort of that's how you should think of a patent. What's really going to drive your value in your company is also having a great product, having a solid customer base, all these sorts of things, being the first mover, first on the scene, creative branding, all these sorts of things, and a patent in your back pocket in case anybody acts up.
Okay, great. Thank you so much.
Happy to help.
Charlie.